Evening, everyone, and welcome to our weekly study session for the Ohio Division of Real Estate Salesperson exam. My name is Michael Rapaski, and I'm the team leader and CEO of Keller Williams Greater Metropolitan, and excited to have you guys here with us tonight. We're gonna wrap up a little bit early tonight, as I got to get my stiletto out the door to my next appointment. But in the meantime, let's maximize the next 40 minutes or so that we can help you guys get ready for the exam. I am going to put my email and contact information in the chat. If you have not applied to the Ohio Division of Real Estate, if you have not scheduled your exam, if you need help with that, please reach out to me. I'll get you put in touch. I'll put you in touch with someone who can, or one of our team members who coordinates all of that. Now, what do we want to cover tonight? What do we want to cover this evening? Go ahead and put in the chat what topics, what subject matters, what sections you want to hit on to brush up on tonight. Go ahead and get those into the chat. We'll build a log of everything that we want to cover, and then we'll hammer through it this evening. All right, what do we have? Finance, contracts, and contracts. One more topic to hit this evening. What else we want to give me a third topic here, guys? Property ownership. Okay, great. We'll start with property ownership. We'll go to finance, and we'll wrap up with contracts. Where's property ownership? There it is. Okay, great. All right. So I'm going to read the question, read the answers, and then you just put an A, B, C, or D in the chat. Question number 1. Which is not limited common area? Is it A, the unit the manager lives in, B, assigned parking, C, the patio of a unit, or D, the foyer of a unit? Which one of these is not limited common area? All right, so a few A's in the chat. We'll go with that. The unit the manager lives in is your foyer is a part of your unit, therefore is not common area. Assigned parking, patios, and managerial or office units are all limited common areas. But anything inside of your unit, including a foyer, is not going to be limited common area. Question number 2. Rich buys a tract of land and receives an easement to cross Sam's property to access a community lake. Rich is benefiting from the easement and thus has A, a dominant estate, B, an encumbrance, C, encroachment, or D, a servient estate. Yep. If you're the one benefiting from the easement, then you have a dominant estate. The servient estate is the person who's giving the easement. Question number 3. Mr. Green gives a life estate to Sandra. Upon Sandra's death, the estate will go to Mr. Blue. Mr. Blue's interest is known as what? Is it A, a remainder interest, B, a reversionary interest, C, a contract for deed, or D, a leasehold interest? A remainder interest is going to be correct. So the thing to consider here is upon death in this life estate, the property will then remain with someone other than the person granting the estate. If it was going back to Mr. Green, that would be a reversionary estate where it would revert back to Mr. Green. But since it moves on to remain with somebody else, it is a remainder interest. Question number 4. Jack gives a life estate to Jill for so long as Bob lives. Upon Bob's death, the property will pass to Larry. What are the interests of Jill and Larry? Is it A, an ordinary life estate with remainder, B, an ordinary life estate with reversion, C, pure atre V with remainder, or pure atre V with reversion? All right, we got an A, a B, and a C. So let's talk through this. Larry is going to receive the property after death, and Jack's giving it. So it can't be reversion, right? It can't be a reversionary state, because for it to be reversionary, it'd have to go back to Jack. So we know that B and D are out. So then it's A or C. So what type of life estate do we have? An ordinary life estate, you get it as long as you live, or an inordinary or unordinary life estate, which says you get it as long as somebody else lives for the life, or Latin for pure atre V. So it should be C, and it's C. Question number 5. An example of a natural attachment to real property is A, an electrical pole, B, landscaping, C, a garden bench, or D, a chain link fence. All right, looks like the B's have it, and that is correct. Natural attachments. The only one listed there is landscaping, right? Garden benches, telephone poles, fences. Well, garden benches are personal property because they're movable. Chain link fences are going to be man-made attachments, and the electrical pole is going to be part of a utility company's easement. Question number 6, which is both a lien and an encumbrance on a property? Is it A, a license, B, a deed restriction, C, an easement, or D, a mortgage? D is correct. A mortgage is both a lien and an encumbrance. Question number 7, all property is classified as either real or A, easements, B, personal, C, implements, or D, fixtures. B, real or personal, guys. Real or personal. Fixtures are attachments to real property. Implements are crops. And easements are encumbrances. Question number 8. The highest and best form of ownership interest in real estate is called A, leasehold, B, fee simple conditional, C, life estate, or D, as you all have nailed, fee simple absolute. It is fee simple absolute. That is the highest and best form of ownership. Question number 9, which is not appurtenant to real property? A deed of trust, B, an easement, C, mineral rights, or D, chattels. Couple A's and a couple D's. Somebody break the tie. All right, the A's have it. And D was the correct answer. Chattel is personal property and does not stay with the land. A deed of trust in mortgage states, a deed of trust, excuse me, is a mortgage in some states and is appurtenant to ownership unless steps are taken to remove it from the title. A little bit of a tricky question, but chattels are definitely personal property and would be an appurtenance to the property. And finally, which is considered real property? A, implements, B, light fixtures, C, area rugs over a hardwood floor, or D, a tenant's fixtures. We got 3 B's, a D, and an A. We'll go with B, as that's our majority. And that's correct. Light fixtures are considered a part of the home, making them real property. Tenant fixtures, that qualifier of tenant fixtures is going to be a real priority there because you can suppose that they were not there prior to the tenant leasing the property. All right, good job, gang. We'll go back to hit financing. Question number 1. A viable alternative to foreclosure would be A, filing a lis pendens notice, B, filing a writ of execution, C, filing an attachment, or D, filing a deed in lieu of foreclosure. D is correct. A deed in lieu of foreclosure is turning over that deed so you can avoid foreclosure. Question number 2. Purchaser secured a loan using a deed of trust. Now that the borrower has defaulted on the loan, the trustee finds a buyer to sell the title to. Which instrument did the trustee use to convey the title to the new owner? A, a reconveyance deed, B, a trustee deed, C, a quitclaim deed, or D, a deed of trust? All right, looks like we've got a few D's and a few A's, or maybe those D's were from the last question. We'll go with A. And it was B, a trustee deed. A trustee deed is going to be the correct answer there. And that puts the title into trust where it stays. Or excuse me. Let me get you the right definition. In default, the trustee is instructed by the lender to sell the property. When this happens, the trustee uses a trustee deed. So the trustee being involved is going to be your trigger for it to be a trustee deed. Question number 3, all of the following statutes require disclosure of closing costs except A, RESPA, B, Regulation Z, C, Truth in Lending, or D, the Fair Credit Reporting Act. So the Fair Credit, I'm not gonna let you guys stray from the course here. RESPA is the Real Estate Settlement Procedures Act. Truth in Lending and Regulation Z, all 3 of those require the disclosure of closing costs. Fair Credit Reporting Act does not. The Fair Credit Reporting Act is simply related to who gets whose credit information and what information is available, right? That has nothing to do with closing costs. That's more with the pre-approval process, not the closing. Truth in Lending and Regulation Z and RESPA all require disclosure of closing costs. Question number 4, what financing method does not use 2 ratios for qualification? A, the VA, B, the FHA, C, a conforming conventional, or D, all of these actually use 2 ratios? Which one of these use 2 ratios? Debt to income, debt to equity. All right, the D is popping in the chat. It's actually the VA does not use that. They use the residual income method in lieu of the housing expense ratio. Residual income is what the VA has, the veteran rather, has left after paying taxes and housing expenses. Question number 5, lender advertises that there are reasonable monthly terms for the purchase of a home. Which disclosure is necessary? A, the interest rate and the interest paid over the life of the loan. B, the interest rate. C, no disclosure is necessary. Or D, the monthly mortgage payments. They're advertising reasonable monthly terms. Two B's and a C. And a D. The answer here should be C. And the reason for that is a statement like reasonable monthly terms available doesn't necessitate any disclosure because it's a subjective terminology. Disclosing any individual item, interest rate, monthly payments, or amount of interest paid over the life of the loan, those all require the disclosure then of everything. They're triggering events, right? Which would say, hey, if you're going to share one of these, you got to share all of them. But if you don't share any of them, you don't have to share any of them. Question number 6, after the borrower makes the last payment on the loan secured by a deed of trust, which instrument will the trustee use to revest the title to the borrower? Is it A, a limited warranty, B, a general warranty, C, a trustee deed, or D, a reconveyance deed? Yeah, it's going to be D, a reconveyance deed. because they're going to reconvey that title back to the mortgagor. Question number 7. Just one day prior to a foreclosure, the homeowner pays the bank all past due payments, late charges, attorney fees, etc. The homeowner saves the property under the right called A, the defeasance clause, B, the equitable right of redemption, C, the anticipatory repudiation, or D, the statutory right of redemption. Okay, couple of B's here, and that's going to be correct. The equitable right of redemption is exactly what's taking place here. The statutory right of redemption occurs after a sale has taken place on the property. So that's the difference there, and involves the court and all that. So it does not, equitable right of redemption doesn't. It just means that you're late, and then you're paid up. Question number 8, which is a document that uses real property to secure debt? A, a promissory note, B, a mortgage, C, a trustee deed, or D, chattel. B, mortgage is going to be correct. That is when you purchase a property, you are getting a purchase money mortgage. You buy the mortgage and then you leverage that property for that money, right? It's a simultaneous transaction, but that property, that real property, that land, that house secures the debt. And so that is what a mortgage does. One form of seller financing is A, a lease purchase, B, a land contract, C, a lease option, or D, non-conforming. Which one is a form of seller financing? Yes, the land contract is the most common form of seller financing. Question number 10, what type of note calls for interest payments only during the term of the loan, with the principal due at the end of the loan? Is this an A, term loan, B, wraparound loan, C, installment loan, or D, amortized loan? This is you're making interest only payments throughout the life of the loan, and then at the end, you pay the full principal amount. This is known as a term loan. Amortized loans are where you pay the same amount each time, a little bit of interest and principal. A wraparound loan combines 2 loans and averages the interest rate, and there is no such thing as an installment loan. All right, we'll keep on trucking here. Contracts. You've heard me say it before. I'll say it again. Single largest section on the exam. Know your contracts, and you will put yourself in the best position to pass the national portion of the exam. Question number 1. John and Mary are getting a divorce. John tells Mary that unless she agrees to sell their home immediately and split the proceeds, he will institute legal proceedings to gain custody of the children. If she agrees, the sales contract may be voidable because of A, duress, B, legality of object, C, consideration, or D, offer and acceptance. You guys know this one right off the bat. Duress. You cannot put somebody in an undue, stressful situation and force them into a contract that will potentially make that contract null and void. Question number 2. in a face-to-face meeting, a farmer offers to pay a roofer $1,500 to install a roof on his barn. The roofer says, I'll do it tomorrow. What type of contract do they have here? Is it A, express, B, option, C, unilateral, or D, voidable? What type of contract is this? Nope, you guys are already in. Are you already in? That's from the last question. Maybe it's A. It's express. Expressed in words or in writing. That is the express contract. I want you to do X, Y, and Z. I agree to do X, Y, and Z. An implied contract is one where you drop off your coat at the dry cleaners and they clean it, right? You don't have to have an express contract or sign anything. You simply, dropping a coat off at the dry cleaners implies that they're going to clean it and you're going to pay. Question number 3. An option A keeps the offer open for a specified time. B gives the optionee an easement on the property. C requires the optionor to complete the purchase if the optionee so elects. Or D makes the seller liable for a commission. So C is going to be the correct answer here. The option exists as a unilateral contract where one person gets to decide whether to activate it, right? And it requires the person giving the option is the optionor, the person receiving the option is the optionee. If the optionee elects to activate the option, the optionor has to move forward with it. Question number 4. Seller Joe's agent personally delivers Mary's offer to buy his house. Joe said he would like to think about it for a couple of days. Later that week, without making a single change to the contract, Joe decided to accept Mary's offer and signed it. He then addressed it to Mary, went to the post office and mailed it. Is this contract binding on both parties? A, yes, because that was required. All that was required was Joe's signature. B, no, because Mary didn't receive it from her agent. C, no, because Joe didn't give it back to his agent. Or D, yes, because Joe sent it in the mail to Mary. D is correct. This is known as the mailbox rule. And when it is in the mail, flag up at the post office, postmarked, it is an accepted contract because that means that acceptance has been communicated, right? Question number 5, a listing agreement states that the property will be listed starting today and will terminate upon the property being sold. Which statement is true? A, the listing is invalid because it does not contain a definite date of expiration. B, the listing will lapse within a reasonable amount of time. C, the buyer can determine when the listing will end. Or D, when the property sells, the broker will be due a commission. Which one of these, pray tell, is true? Sorry, guys, I closed my chat box. Yep, A is going to be correct. All listings need a definitive date for expiration. Otherwise, they are not valid. They're not valid, then they are not a listing agreement. All right, let's go on to the next question. All right, getting all my windows sorted out here. Question number 6. A commercial broker listed a storefront for rent. A tenant was procured after the lease was signed. After the lease was signed, the owner refused to pay the listing. In order to obtain her fee, the broker could A, lien the property, B, sue for specific performance, C, file a complaint with the Division of Real Estate, or D, sue in criminal court for because the fee was $30,000. It's like we're between A and B. The A's have it, and that is correct. In commercial real estate, the commercial lien law is what applies. So you're not suing for specific performance since the transaction is closed. You're liening that property until commission is paid. Only in commercial. You don't do that in residential because the title company is going to navigate all of that. Question number 7, who is authorized to rescind a voidable contract? A, only the minor. B, neither party. Only a void contract can be rescinded. C, the agent and the seller only, or D, either party. Yeah, A, only the minor. It's a little bit of a tricky question, guys, because the minor is considered the injured party. The injured party can void contracts. They do not have to, right? They make it voidable, or they can rescind it. But the minor would be someone who cannot otherwise enter into contract. And so that would make them the injured party. Question number 8, a contract is entered into on fraudulent terms introduced by the seller. Upon discovery of the fraud by the buyer, the contract would be A, voidable by the buyer, B, valid, C, voidable by the seller, or D, void. This is going to be voidable by the buyer. It's the same version of that question once again, where there's an injured party. Just because there's fraudulent terms involved doesn't mean that the contract won't potentially go through if the buyer is willing to accept and continue the contract despite that fraud. Question number 9, Adam and Jenny entered into an agreement wherein Adam will buy Jenny's house at the asking price if Jenny will install a new roof and if Adam can qualify for a loan sufficient to cover the purchase. Until the roof is installed, the financing obtained, the contract is said to be A, voidable, B, executed, C, executory, or D, rescinded. Yeah, C is the correct answer here. You'll also hear it referred to as contingent. It's contingent on financing and improvements. Question number 10, an option agreement is A, unilateral contract, B, a bilateral contract, C, both a bilateral and unilateral contract, or D, neither a bilateral or unilateral contract. Options have one person who gets to make the decision, right? Which means that they are a unilateral, like unicycle, as in one tire, one decision maker. Options are unilateral contracts. Question number 11, a large mirror that a buyer wants to remain at the property should A, never be included in the sales contract, B, be disregarded as having no consequence, C, be agreed upon verbally with its price stated in the contract, or D, be identified as a fixture in the sales contract. D is the correct answer. You want to identify that as a fixture because fixtures are attached to real property and transfer with the transfer of real property. So if you want to keep that, identify it as a fixture. If it's not something that can be attached or identified as a fixture and you want it included, it needs to be on a separate real property contract constituted by a bill of sale. Question number 12, Walton decides to sell his cabin on the lake and offers it to his regular postman, Bill, at a price of 5,000 American dollars. The next day, Walton receives a note from a neighbor, a close friend of the postman, who says, I accept your offer. Is Walton obligated to sell to the neighbor? A, yes, because both the offer and the acceptance were in writing. B, yes, because the acceptance was within 3 days. C, no, because only the offeree can accept an offer. Or D, no, because no licensed real estate agent was involved. Yes, the C's have it. It is no, because only an offeree can accept an offer. If I write a contract on your house for $200,000, your neighbor can't say, oh, I'll take it, and then be under contract. Same thing happens with somebody offering to sell. Question number 13, Melissa went to the dry cleaner and dropped off her Goodwill coat to be cleaned. When the clerk accepted the coat, Melissa and the dry cleaning operation had just entered into which type of contract? Is it A, unilateral, B, executed, C, implied, or D, complete? I gave you this one earlier and you guys are all over it. C, implied. Question number 14, a seller signs a listing agreement that commences today and ends on December 31st. The listing agent tries as hard as possible, but simply can't find a buyer who's interested in the property. After the first of the year, the listing is terminated by A, unilateral agreement, B, seller recession, C, statute of fraud, or D, expiration. Expiration is right. Just like the milk in your fridge, if it goes past the date, you are no longer good. And last question of the evening, which is true of a voidable contract? A, a voidable contract may be enforceable at the option of the innocent party. B, all parties of contract must have reached 16 years of age or it can be voided. C, a forged contract is voidable. Or D, a signed real estate contract cannot be voided. I see more A's than anything else, and that's correct. Only injured parties can void the contracts, but they don't have to, giving them the option. Reasons might include intoxication, menace, duress, fraud, misrepresentation, or minority status as a minor. If the contract is illegal, it is void automatically. You can't contract people to do illegal things. It is unenforceable and void immediately, right? Good job there, guys. As I said, those are contracts is the most important or largest section on the exam. So very good to master that. I apologize. We're going to cut it a little bit short this evening. Appreciate you guys being here. We are here every Tuesday until the day after Christmas. So we'll have 3 sessions in December. If you have not scheduled your exam, schedule your exam. I'm going to put my name and contact information in the chat again. If you haven't applied yet and you need to do that, we'd love to help you do that. Here for whatever you need. Give me a jingle, give me a text. Appreciate you guys. Have a great night. We'll see you next week.